since the Justice Department missed the deadline to release all of the files related to the Jeffrey Epstein investigation, as required by law. This week, the two House members who led the push to unseal those documents, Republican Thomas Massie and Democrat Ro Khanna, asked a federal judge to step in and appoint a special master to ensure all the documents are released.
Trump just got blindsided by a federal judge, and this ruling changes everything about the Epstein files cover-up. Judge Angel Muir, who's been supervising the Ghislaine Maxwell case, just issued an order that puts Trump's Department of Justice in an impossible position. The judge is demanding answers about why the DOJ hasn't complied with the Epstein Transparency Act, demanding explanations for why only a tiny fraction of documents have been released. And here's what makes this devastating. The judge gave them a hard deadline: Friday. This Friday, the DOJ has to respond in writing on the public docket explaining whether the court has authority to force them to comply with federal law, whether victims have standing to demand compliance, whether anyone can hold them accountable for violating an act of Congress. And Trump's DOJ is panicking because they thought they could just ignore this law, thought they could slow walk document production forever, thought nobody had authority to force their hand. But now a federal judge is asking pointed questions that expose their entire cover-up strategy. And here we built John Brown Show to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, please subscribe. Your subscription actually matters here. All right, let's get into why this ruling is such a crisis for Trump's DOJ. Because the Epstein Transparency Act passed with near unanimous support in Congress. Democrats and Republicans together demanding full release of all Epstein files. No redactions, no delays, no excuses. The law was crystal clear. Department of Justice must turn over every document related to Jeffrey Epstein's criminal activities and connections to powerful people. And the law set a specific deadline. Documents were supposed to be released over a month ago. Full production. Everything the DOJ has. Every investigation file. Every witness statement. Every piece of evidence connecting Epstein to anyone. Share this video with everyone you know because Trump's DOJ has completely violated this law. They've released roughly 12,500 documents. Sounds like a lot until you realize they owe 125,000 pages. That's less than 10% of what they promised, and they're claiming they still need to review 2 million additional documents. That could be 20 million pages according to their own estimates. And their attitude about this violation is completely casual. Like it's no big deal they're defying federal law. Like Congress can't do anything about it. Like nobody has authority to force compliance. And what makes this worse is the documents they did release were strategically selected. First batch was almost entirely Bill Clinton material. Connections between Clinton and Epstein. Clinton's trips on the plane, Clinton at the island, anything that made Democrats look bad. But mysteriously almost nothing about Trump, nothing about Trump's decades-long friendship with Epstein, nothing about all those parties at Mar-a-Lago, nothing about Trump calling Epstein a terrific guy who likes beautiful women on the younger side. All of that somehow didn't make it into the first release, because Trump's DOJ is playing games, releasing what hurts political enemies, hiding what hurts Trump. Think about what that means. This is systematic cover-up of evidence connecting Trump to a child trafficking operation. And they're doing it by violating federal law, by defying Congress, by slow-walking production until people forget and stop paying attention. That's their strategy. Delay, delay, delay until the public moves on to other scandals, and nobody's demanding Epstein files anymore. Make sure you're subscribed to John Brown Show because that's where Congress members Ro Khanna and Thomas Massie come in. These two representatives, one Democrat, one Republican, worked together on the discharge petition that forced the Epstein Transparency Act to a vote. And they're not letting the DOJ get away with this violation. They filed what's called an amicus brief. That's a friend of the court document. They filed it with Judge Angel Muir, who's supervising Ghislaine Maxwell's criminal case. And their brief says the judge needs to appoint a special master or independent monitor to force DOJ compliance. Here's why that matters. Normally in a criminal case, you have adversarial parties, prosecution on one side, defense on the other, each pushing their own interests, each holding the other accountable. But in this situation, the DOJ and Ghislaine Maxwell are aligned. Both want the files hidden. Neither wants full transparency. The DOJ doesn't want Trump's connections exposed, and Ghislaine doesn't want more evidence of the trafficking operation coming out. So there's no adversarial process. Nobody pushing the DOJ to do what federal law requires. That's why Khanna and Massey are asking for an independent monitor. Someone outside the DOJ. Someone with authority to review those 2 million documents. Someone who can force production on the timeline Congress mandated. Because without that, the DOJ will just keep stalling forever. Keep making excuses about how many pages they need to review. Keep releasing tiny batches strategically designed to protect Trump while hurting his political enemies. And Judge Angelmir's order shows he's taking this seriously. He received the brief from Khanna and Massey, and instead of just dismissing it, he's ordering the DOJ to respond, ordering them to address specific questions about the court's authority, about whether victims have standing, about whether anyone can force compliance with the Epstein Transparency Act. The judge is putting these questions on the public record, making the DOJ answer in writing, making their position clear for everyone to see. Think about what that means. The order lays out 2 critical questions the DOJ must answer. First, whether Khanna and Massey have standing to participate in this criminal case, whether they can raise compliance issues even though they're not parties to the case. And second, whether the court itself has authority to force DOJ compliance. Whether Judge Angelmir can appoint a special master. Whether he can set production deadlines. Whether he can hold the DOJ in contempt if they refuse. These questions go to the heart of whether anyone can hold Trump's DOJ accountable. And the judge's language is revealing. He specifically mentions issues that have not been raised by any party or victim. That word victim is critical, because the judge seems to be hinting that Epstein's victims might have standing even if members of Congress don't. The judge is basically inviting victims' lawyers to file their own motions, to demand the appointment of an independent monitor, to push for full compliance with federal law, because victims have direct interest in seeing all evidence of the trafficking operation exposed. Victims already made their voices heard when the first batch came out. They went on television, did interviews, showed how incomplete and strategically selected that first release was, showed how the DOJ was playing political games with evidence of their abuse, and their testimony was powerful. Made clear that Trump's DOJ isn't serving justice. It's serving Trump's interests by covering up his connections to Epstein. So if victims now file motions demanding an independent monitor, the judge has opened the door. He's signaled he wants to hear from them, wants their input on whether the court should intervene. And that creates a path forward. Even if Khanna and Massey lack standing as members of Congress, the victims can step in, can demand accountability, can force the issue in ways Congress can't. And here's why Trump's DOJ is panicking about this, because they have no good answers to the judge's questions. If they admit the court lacks authority to enforce the Epstein Transparency Act, then they're admitting Congress passed a law with no enforcement mechanism, that the act is toothless, that they can violate it with impunity. But saying that publicly on a court docket creates enormous political backlash, makes clear they're thumbing their nose at Congress, at victims, at everyone demanding transparency. But if they admit the court does have authority, then they're inviting judicial supervision. They're opening the door to a special master reviewing their work, to court-ordered production deadlines, to contempt sanctions if they don't comply. And that's exactly what they've been trying to avoid, because an independent monitor would expose their cover-up, would see all the Trump documents they're hiding, would force release of materials that destroy Trump's denials about knowing what Epstein was doing. Think about what that means. So Trump's DOJ is trapped between 2 bad options. Admit they're violating federal law and dare anyone to stop them, or submit to judicial oversight that exposes what they're covering up. Either way, they lose. Either way, their strategy of quiet delay and selective release gets destroyed. And that's why the judge's order is so devastating, even though it's phrased as questions. Now let's talk about what the DOJ has actually produced and what they're still hiding. In prior filings to Judge Angelmir, before the Epstein Transparency Act, even past the DOJ listed specific categories of documents they would turn over, made promises about what would be released, and now in status reports they're casually admitting they haven't kept those promises. They've turned over some documents, but they still owe the vast majority, and they're acting like this is just a minor delay, just a gentle status update, like violating federal law is no big deal. And the DOJ's excuse is they need more time to review documents for classification and privilege. But that excuse falls apart under scrutiny. First, the Epstein Transparency Act specifically overrode classification concerns. Congress decided transparency was more important than keeping these files secret, so classification can't be used as excuse for delay. Second, the DOJ already reviewed these documents when they were investigating Epstein. They know what's in the files. They're not starting from scratch. This is manufactured delay designed to run out the clock. And third, the strategic nature of the first release proves this isn't about careful review. It's about political manipulation. They somehow managed to review and release all the Bill Clinton material immediately. All the documents that make Democrats look bad. But they need years, apparently, to review Trump material. Documents about Trump's friendship with Epstein, about parties at Mar-a-Lago, about Trump's public comments praising Epstein. All of that requires extensive review, apparently, while Clinton stuff could be dumped immediately. That double standard exposes the cover-up, shows the DOJ isn't acting in good faith, shows they're using the review process to hide what hurts Trump while releasing what hurts his enemies. And now a federal judge is asking them to explain that, to justify their selective compliance, to defend their violation of federal law on the public record. Share this with everyone because there's another layer to this that makes Trump's panic worse. The number 2 official at Trump's DOJ is Todd Blanche. And Todd Blanche has connections to this case that create massive conflicts of interest. He was involved in negotiations with Ghislaine Maxwell, was part of her transfer to minimum security facility, was present when she gave interviews that produced sound bites helpful to Trump. Sound bites that were later proven false when documents from the Epstein estate came out. So the person overseeing DOJ compliance with the Epstein Transparency Act has personal involvement in protecting Ghislaine Maxwell, has worked to make her situation better, has coordinated with her to produce false narratives helpful to Trump, and now he's in charge of deciding which documents about Epstein get released and which stay hidden. That's not conflict of interest. That's active participation in cover-up. And Judge Angelmir's order puts pressure on that entire corrupt system. By asking whether the court has authority to supervise compliance, the judge is threatening to cut Blanche out of the process, to appoint someone independent, someone without ties to Trump or Maxwell, someone who will actually follow the law Congress passed. Think about what that means. Now, there's also a broader question about what happens when the DOJ itself becomes a criminal enterprise. Because that's what we're looking at here. The Department of Justice is violating federal law. The Epstein Transparency Act is law. It has force. It mandates specific actions. And the DOJ is refusing to comply. That's a crime. That's obstruction. Everyone involved in the decision to slow walk production is participating in criminal violation of federal law. But who prosecutes the prosecutors? The DOJ investigates crimes. The DOJ brings charges. But when the DOJ itself is the criminal enterprise, there's no mechanism for accountability. Congress can hold hearings, can demand answers, but can't prosecute. The courts can find contempt, can impose sanctions, but can't bring criminal charges. Only the DOJ can prosecute, and the DOJ isn't going to prosecute itself for covering up Trump's Epstein connections. That's the fundamental crisis here. Our system depends on a Justice Department that respects the law. That follows congressional mandates. That serves public interest, not presidential interest. But Trump's DOJ has abandoned all of that, has become a tool for protecting Trump, for covering up his crimes, for defying Congress when Congress demands transparency. And the only remedy is external pressure. Judicial pressure through orders like Judge Angelmir's, political pressure through members like Khanna and Massey, public pressure through victims speaking out. All of that together might force compliance, might break through the wall of obstruction, might finally get the full truth about Trump and Epstein released. Make sure you're subscribed to John Brown's show because Friday's deadline is critical. When the DOJ files its response, we'll see their legal arguments. We'll see whether they claim the court lacks authority, whether they dare to admit they're violating federal law, whether they offer any justification beyond "we don't feel like complying," and that response will be public, will be on the docket. will be available for everyone to read and analyze. And if the DOJ's response is weak, which it almost certainly will be, then victims can file their own motions, can point out the inadequacy of DOJ's arguments, can demand judicial intervention, can force the judge to rule on whether he has authority to appoint a special master. And that ruling, whatever it is, will clarify whether there's any mechanism to enforce the Epstein Transparency Act. If the judge rules he does have authority, then we get independent oversight. We get someone forcing full production. We get the cover-up exposed. But even if the judge rules he lacks authority, that's valuable too, because it proves Congress passed a defective law, proves there's no enforcement mechanism. And that creates pressure for Congress to fix it, to pass new legislation with clear enforcement, with criminal penalties for officials who refuse to comply, with mandatory appointment of special masters in cases like this. Either way, Trump loses. Either way, the cover-up gets harder to maintain. Either way, public attention stays focused on why the DOJ is hiding Epstein files, on what Trump's connections to Epstein really were, on why Trump fought so hard against the Epstein Transparency Act in the first place. Think about what that means, because that's the question that hangs over everything. Why was Trump so determined to prevent release of these files? If he had nothing to hide, if his relationship with Epstein was innocent, if all those parties and flights and photographs meant nothing, then why fight transparency? Why violate federal law to keep documents hidden? Why risk judicial contempt and political backlash and public outrage? The answer is obvious. Trump has something to hide, something in those files that would destroy his denials, something that connects him directly to Epstein's operation, and he's willing to corrupt the entire Justice Department to keep it hidden, willing to violate congressional mandates, willing to defy federal judges, willing to do whatever it takes to prevent full truth from coming out. But Judge Angelmir's order shows the walls are closing in, shows Trump's obstruction strategy is facing real challenges, shows there are still judges willing to ask hard questions, still members of Congress willing to fight, still victims willing to demand justice. And all of that together creates pressure Trump can't escape. Bottom line is this: Trump just got blindsided by federal judge Angelmir, who issued an order demanding DOJ explain its failure to comply with Epstein Transparency Act. Judge gave them until Friday to respond in writing on public docket, must address whether court has authority to force compliance, whether victims have standing to demand action, whether anyone can hold DOJ accountable for violating federal law. DOJ has only released 10% of documents they owe. 12,500 documents out of 125,000 pages promised, claiming they need to review 2 million more documents. But their casual attitude about violating congressional mandate shows this is deliberate delay, not good faith effort. First batch released was strategically selected Clinton material. Nothing about Trump, despite his decades-long friendship with Epstein, proves DOJ playing political games, releasing what hurts enemies, hiding what hurts Trump. That's not compliance with law. That's cover-up using federal law enforcement apparatus. Congress members Khanna and Massey filed amicus brief demanding appointment of special master to force compliance. Judge is taking it seriously, ordering DOJ to respond to their arguments, opening door for victims to file their own motions demanding intervention, creating path forward even if members of Congress lack standing. Judge's order traps DOJ between admitting court lacks authority, making law toothless, or submitting to judicial oversight that exposes cover-up. Either option destroys their strategy of quiet delay and selective release. Either way, they lose. Todd Blanche, number 2 at DOJ, has personal involvement in Maxwell case, coordinated her transfer to minimum security, present for interviews producing false pro-Trump narratives, now oversees compliance with transparency law. That's not conflict of interest, that's active participation in cover-up. When DOJ itself becomes criminal, enterprise violating federal law, there's no prosecution mechanism. They investigate crimes, they bring charges, but won't prosecute themselves for covering up Trump's Epstein connections. Only remedy is external pressure, judicial orders, congressional demands, victim advocacy, public outrage. Friday deadline forces DOJ to show their hand. Response will be public, will reveal their legal arguments, will expose weakness of their position, And that creates opportunity for victims to intervene, for judge to rule on his authority, for enforcement mechanisms to finally activate. Trump fought transparency because he has something to hide. Something in those files connecting him to Epstein's operation. Something that destroys his denials. That's why he's corrupting Justice Department, violating congressional mandates, defying federal law to keep truth buried, but walls are closing in. Judge asking hard questions, deadline approaching, cover-up getting harder to maintain. This story continues. Stay tuned.